Hello CMA inter students. We can have a quick revision into corporate laws part of your business laws and ethics paper. So since this is a fast track revision, we will be discussing only the important and major areas from each and every chapter. So this discussion is limited to your corporate laws part only. So first we will move to the concept of companies, incorporation of companies and matters incidental thereto. That is the first part in your syllabus. So company is defined as a company which is incorporated under Companies Act 2013 or any other previous company law. Then characteristics of company. It is a separate legal entity. Apart from members, it is having a separate existence. The liability of members of company is limited. The limited liability concept may be classified into three types. It may be either limited by shares up to the amount unpaid on face value, limited by guarantee up to the amount guaranteed at the time of becoming member, or company having unlimited liability. So this can be further classified. Limited liability concept can be further classified into either it may be company limited by shares, company having a company limited by guarantee, or company having unlimited liability. Then there is a feature of perpetual succession. Apart from the members, the company is having an existence because it is an artificial person which is created by law. Separate property means company can own property in its name. Common seal. The concept of common seal is not mandatory now. It can be either signed by two directors or one director and company secretary. Transferability of shares. The shares in a company are freely transferable, but there is an exemption in your private limited company. The shares of private limited companies are not freely transferable. There are certain restrictions that we'll be discussing. Capacity to sue and be sued. The company, being an artificial person, can sue and it can also be sued. Then now we'll move to the concept of corporate veil. See, we discussed about the separate legal entity concept of a company. Company is having a separate entity apart from its members. So that particular feature of a company has to be used only for legal or legitimate purposes. Okay, so if we are using this particular feature, this important feature, for any fraudulent purpose or any dishonest purpose, the court will be removing or breaking the corporate shell that the members of the company is enjoying. Means the members and the company is two different entities. So if it is used, if this feature is used for any dishonest purpose, that will be broken, and the persons who are behind the company, hiding behind the company, will be punished. Okay, so lifting of corporate veil may happen in these circumstances: if there is any protection of revenue, which means if there is any tax evasion, they will be removing the corporate shell. Then determination of enemy character of company. If our country is having a war with any other country, the country will be checking whether that citizens of that country is members of any company and all. Okay, suppose if our country is having a bad situation, war situation with any country, X country, so at that time our country will be checking which all companies are having the citizens of that particular country. Then prevention of fraud, protection of a public policy. When company is mere a clock or sham, it is just an arrangement to avoid any loss. If company is just a temporary arrangement, the corporate veil concept will be broken. Company is acting as agent of shareholders, avoidance of any welfare laws to punish for contempt of court. Okay, so under these circumstances, the court will be removing the corporate shell and they will be punishing the members who are behind, taking shelter behind that corporate shell. Okay, then now we'll move to the types of companies: private company and public company. When we are discussing the company, this concept of types of company on the type of members, classification of company on the type of number of. Okay, so when we are discussing the types of company on the basis of number of members, you can have a private company, public company, Then private company can further be classified into normal private company, which is explained in section 2 clause 68, 2 clause 85 for small company. Then small company is explained in 2 clause 62. So my point is that small company and one person company is another classification of your private company. So when you are classifying the company on the basis of number of members, broad classification is it may either be private or public. Then private can again be classified into normal private company, then small company and one person company. We'll discuss one by one. In private company, there will be three restrictions which is mentioned in its articles of association. Number one, it restricts transferability of shares. You have to use the keyword restrict. Don't use that keyword prohibit, because it is entirely wrong. There is restriction among the members regarding transfer of shares. It doesn't mean that the members of private company cannot transfer its shares. It will be having certain restriction. For example, if a member of a private company want to or wish to transfer its shares, companies articles may be mentioning that if you want to transfer your shares, first you have to offer the shares to the existing members. If they are not willing to purchase, only you can give it to outsiders. Such restrictions may be there in articles. Okay, doesn't mean that in private company you cannot transfer the shares. Limits the number of members to 200. So while counting the number of members of 200, you will be excluding two members. Number one is persons who are in employment of the company. Number two, persons who were in employment of the company. Or to a person, if you have given shares to a person while that person was in employment of company, and that person later ceased to be the employee of company. For example, that person resigned from the company, still that person will not be counted for 200. He will be enjoying or she will be enjoying all the privileges of member, all the entitlement of member, but they will not be counted for this 200. Prohibits invitation to public to subscribe any securities of company. Okay, public offer is prohibited in private limited company. Public company is a company in which is not a private limited company. If it is not private limited, it will be public company. So one person company is explained in section 2 clause 68. A sole member will be there, nominee will be there. Then in the case of death or incapacity of sole member, nominee will be taking charge as a sole member. Then sole member and nominee has to be natural person, Indian citizen, may or may not be resident. It is not mandatory now that your sole member and nominee has to be resident. So residential status will be counted on the basis of previous year's stay, that is 120 days. If a person has stayed in India, resided in India for 120 days or above in the preceding financial year, he will be classified as resident. It was earlier 182, now it is 120 days only. A person can become sole member in only one OPC. Person can be nominee in only one OPC. Consent has to be obtained by sole member in form number INC 4. If a person becomes sole member in more than one OPC by operation of any law, suppose by death of a person is becoming sole member in two OPC at the same time. Okay, so that person will have to determine in which OPC he has to continue within a period of 180 days. Okay, then minor cannot become sole member or nominee. Minor cannot hold beneficial interest or he cannot become nominee. OPC cannot be converted to Section 8 company. OPC cannot undertake non-banking financial activities or investment in securities. Okay, so these are the major provisions related to one person company. Now we will discuss the situations in which the nominee of one person company changes. So there are three situations: withdrawal of consent by nominee. A person can become nominee in only one OPC. So if a person want to withdraw his consent, that is possible. So sole member will have to find new nominee, obtain consent and file with ROC. The sole member can change the nominee, or if the nominee expires or if the nominee become insolvent, the sole member is having right to change the nominee. He has to find new nominee, file the form with ROC. In the case of death or incapacity of sole member, nominee will be becoming the sole member. Nominee, the new sole member will have to find a new nominee and file the details with ROC after getting the consent. Then first, one thing that you have to note is that there is a provision regarding Rule 6 and Rule 7, which is conversion of OPC to private or public, then conversion of private or public to OPC, Rule number 7. So some provisions in these rules have been amended. That is, when you are converting OPC to private or public, there were some restriction regarding expiry of 2 years, or if the paid up is exceeding 50 lakh, or if the average turnover is exceeding 2 crore, etc. That provision has now been omitted. There is no such provision. So you can convert your OPC into private or public by complying with the provisions of section 18. So there is no requirement of expiration of 2 years or exceeding of 50 lakh regarding your paid up, or exceeding 2 crore with respect to your turnover, etc. Okay. Then when you are converting your private or public to OPC, there is requirement of special resolution and NOC from members and creditors. The paid up capital, it should be within 50 lakh, and it should be average turnover should be within 2 crore. Such provision was there. That requirement is also now omitted. There is no such provision. Then small company is a type of private company whose paid up capital does not exceed rupees 4 crore and turnover does not exceed rupees 40 crore. If a private company satisfies these two conditions, you can say that such private company is a small private company. These private limited companies cannot become small company. Number one, holding company, subsidiary company, Section 8 company, company governed under Special Act. These companies cannot become small company. Then Section 8 company, companies which are formed and having object for promotion of art, science, commerce, charity, etc. They have to apply the profit or income for the object for which it was formed, and prohibits payment of dividend to its members. As you know that it is having the privilege of all the privileges of a limited company. There is no requirement of adding private limited, public or limited, etc. Then firm can be member in Section 8 company, etc. Okay. So under these three circumstances, the license of Section 8 company will be revoked, contravention of any conditions, then conducting affairs of Section 8 company fraudulently, or violating the objects of company, or acting prejudicial to public interest. Okay, when your Section 8 company is revoked, it may either be converted to private or public. But the problem is that it is not for profit company. There will be a lot of beneficiaries behind that company. So when you are winding up that company, that surplus of that company will be transferred to similar company or insolvency and bankruptcy fund. The third option is that you have to, or you can amalgamate with another Section 8 company which is having similar object. The main core object of this is that if a Section 8 company is not functioning from a particular date, the beneficiaries of those company should not be affected, because that is a non-government organization, or it is a not-for-profit organization. Okay. Then government company is a company whose minimum 51% of paid up is held by central government, state government or state governments jointly by central and state government. Subsidiary of a government company is also treated as government company. Then you have a foreign company. It is a company or body corporate incorporated outside India. That is the first condition, and they have to satisfy these conditions also. It should be having a place of business in India, whether by itself or through agents, by physical or e-mode, and they are conducting any activity in India in any other manner. So if any of this condition, which is if this condition or conducting any activity in India in any other manner, if any of this condition is satisfied, then again also such company will be treated as foreign company. Okay. So the summary is that if a company or body corporate which is incorporated outside India and which is satisfying any of this condition, the meaning is that even though this is written as an, it is having the meaning of or. Okay. Then companies classification on the basis of control. There is holding company, subsidiary company and associate company. Holding company in relation to one or more company. If a company in which other companies are subsidiaries, means that company is holding company. You are taking three companies, other two companies are subsidiaries, means the third company will be the holding company. Subsidiary means a company in which holding company controls composition of board, appointing more than 50% of directors or exercises more than 50% of voting power. Okay. Associate company in which such other company has significant influence. Significant influence means 20% or more of voting power or participation in business decision under an agreement. Okay. Then you will move to the charter documents of a company for incorporation. The main documents are memorandum of company, it is the constitution of company, articles of association of company, which explains the regulation which are applicable to a company. Okay, so we will discuss the provisions or the contents of memorandum of association, name clause, registered office, domicile or situation clause, object clause, liability, declaration clause, nomination clause. So name clause will be containing the name of company and the suffix like private limited, limited, OPC private limited, etc. So if there is any change in the name, or if you are converting your company to private to public or public to private, there will be alteration of name clause. Okay, so name clause contains two segments. Number one is name of company. So while you are selecting the name, there are certain conditions. The name should not be identical, similar to any existing name. It should not be undesirable in the opinion of government, etc. Okay, or if you are changing the name, or if you are changing the suffix limited or private limited, there will be alteration of your name clause. Then registered office clause will be explaining the state in which the company's registered office is situated. Every company, as per section 12, every company should be having a registered office. Okay, physical address should be there to receive and acknowledge all the communications which are sent to that particular company, and your registered office should be there within 30 days of incorporation of company. Okay, but in memorandum, the registered office clause will be mentioning the state in which the company's registered office is situated. So if you are shifting the registered office from one state to another state, there will be alteration in registered office clause. Object clause explains to for achieving what objects the company has incorporated. If you are performing anything over and above the object clause, it will be known as ultra vires, and the ultra vires transaction will be void. Your object clause can also be altered by passing special resolution. As I mentioned, the liability may be either liability by limited by shares, then limited by guarantee, or having unlimited liability. This can also be altered. Then declaration or subscription clause and nomination clause, the details of nominee in one person company. Okay, then format of memorandum of association is table A is for limited by shares, B for limited by guarantee and not having share capital, C for limited by guarantee and having share capital, table D limit having unlimited liability, not having share capital, having unlimited liability and having share capital, for and which will be table E. Then format of articles of association, table F for limited by shares, G for limited by guarantee and having share capital, H for limited by guarantee and not having share capital, I for having unlimited liability and having share capital, J for having unlimited liability and not having share capital. Okay, so your articles can also be altered by passing special resolution. Okay, as I mentioned earlier, articles of association contains the regulations for the management of the company. Okay, if you want to alter any regulations, if you want to change, omit any regulation, you can pass the same, pass special resolution and alter your articles of association. Now we will move to the incorporation of companies process. You have to reserve a name through Spice Plus portal, which is simplified pro forma for incorporating companies electronically. You can reserve the name for a period of 20 days by giving a payment of rupees 1000. Application for incorporation to be filed online through Spice Plus along with certain documents. That documents are memorandum of association articles which are duly signed, declaration by person engaged in formation of company and person named as director, manager, secretary that all required provisions are complied, declaration from directors and subscribers and first directors that they are not convicted for any offense, they are not found guilty in the preceding 5 years, information contained are true, correct and best of their knowledge, then address of correspondence, particulars of subscribers, first directors, details of interest of directors in any other concern. And if registrar is satisfied, he may issue certificate of incorporation and corporate identity number along with PAN, TAN, etc. will be given in your certificate of incorporation. Okay, so we'll now move to the second part, which is prospectus and allotment of securities. So while discussing this part, just understand issue of securities in two companies can be different. you are having two companies on the basis of number of members, private and public companies. So when you are issuing shares in private company, you are having options like right issue, bonus issue, private placement. Okay. In the case of public company, you will be having a public offer extra. Okay. Public offer can either be initial public offer, further public offer, or offer for sales. Okay. We'll be discussing each and every point in detail. So, a prospectus is any document which is issued or described as prospectus, including shelf and red herring prospectus. We'll discuss that in coming session. Then, notice, circular, advertisement, any other document issued to subscribe or purchase securities of body corporate is also known as prospectus. See, there are two kinds of prospectus which I have explained earlier. One is shelf prospectus and red herring prospectus. Okay, so if you want to issue shares for over a period of time, that means if you want to issue shares or if you are issuing shares to public within a period of 1 year, again and again you will have to print the prospectus, again and again you will have to draft the prospectus. That is something that will consume a lot of time from your end. Okay, so in that case what you can do is that you can register a shelf prospectus. A shelf prospectus is a prospectus in which the security specified can be issued for a period of 1 year without issuing further prospectus. If you are registering a shelf prospectus, for the subsequent issue there is no need to print another prospectus. You can use the old shelf prospectus itself. But within the period, means if you have first registered the shelf prospectus in the month of April and you are going to make another issue in the month of June, there is a gap, and within that gap some financial details of the company might have changed. So what you have to do is that you have to include such changes in information memorandum. So the shelf prospectus along with the changes, that is information memorandum, will become the prospectus of subsequent issue. Okay. Then there is red herring prospectus. In the case of book building, you know that we will not be aware of the price of the securities or how many securities we will be issuing. Okay, so in certain that circumstances, you will be issuing red herring prospectus. So it is the prospectus which is issued at the time of book building. Details of price of securities and number of shares will not be included in red herring prospectus. That details cannot be included because we will not be knowing at what price you are going to issue or how many securities you will be issuing. Sorry. Then we are having misstatement and liabilities with respect to prospectus. 34 deals with criminal liability, which will be for person who is authorizing the prospectus. Civil liability, section 35, that is for compensation. So that liable person will be, expert will be liable, promoter will be liable, director, person authorizing the prospectus, or person authorizing to become the director of company. Then liability for fraudulently inducing person to invest, that person will be liable under section 447. Okay. Then again, with respect to private placement, one more, section 42, private placement is there in this chapter. Private placement means where you are issuing securities to selected number of persons, which shall not exceed 200 persons in a financial year. Okay, so while computing this 200 employees to whom employee stock option plan is given, then qualified institutional placement is given, will not be counted. Okay, apart from these two, can give to these shares, private placement can be offered to 200 persons in a financial year. Now we will move to the chapter share capital and debentures. So while discussing this chapter, there are two kinds of shares. One is equity share, number two is preference share. Preference share is having preference over equity shares in two circumstances. Number one, payment of dividend. Number two, repayment of capital at the time of winding up. Okay, then voting power, equity shares will be having right to vote on every resolution which are placed before the company. Normally preference share capital will not be having any voting right, but they will be having voting right in certain circumstances if their dividend is in arrears for 2 years or above. Okay, if the meeting, the item or the discussion in the meeting is related to the rights of preference shareholders, or in the case of winding up of company, preference shareholders will be having voting power. In other situations, they will not be having voting power. voting power will be restricted to equity shareholders. The shares can be issued either at par, at discount, or at premium. So there is no condition, there is no restriction regarding issue of shares at premium. But you cannot issue your shares at discount except in two circumstances. Okay, so when you are issuing shares at premium, there is no limit, there is no condition, there is no restriction, but the amount of security premium can be used for these purposes as per section 52 of Companies Act. Issue of bonus shares, writing preliminary expenses of company, writing of discount or commission or expenses on issue of shares and debentures, payment of premium amount on redemption of preference shares, buyback of shares. Then issue of shares at discount. Issuing shares at discount is prohibited and void. Company can issue shares at discount in two circumstances. Number one, issue of sweat equity shares. It is not sweet, it is sweat equity shares. Issue of shares to creditors when debt is converted to equity as a part of debt restructuring plan or statutory resolution plan approved by RBI or Banking Regulation Act. Then we are having equity shares with differential voting power, which is commonly known as DVR. So with respect to DVR, you will be requiring authorization in articles. Ordinary resolution has to be passed. Listed company has to pass ordinary resolution in postal ballot. Then the limit is 76%. Okay, the voting power with respect to your DVR should not exceed 76%. You are having sweat equity shares. Sweat equity shares are issued to employees or directors, which is issued at discount or consideration other than cash, issued for making available rights in the form of IPR, know-how, value additions, etc. Okay, so with respect to your sweat equity shares, it shall be locked in, it shall be having a lock-in period. Then the maximum limit of providing or issuing sweat equity shares is 15% of paid up or 5 crore, whichever is higher. Then in any financial year, you cannot issue sweat equity shares over a prescribed limit, etc. Okay, then we are having the provisions related to issue and redemption of preference share. Okay, so preference share can be issued by passing special resolution. Then period of redemption of preference shares shall not exceed 20 years. That is, you cannot issue irredeemable preference shares from the commencement of Companies Act 2013. Okay, that means your preference shares should be redeemed within 20 years from the date of issue. But the companies which are engaged in infrastructure project can issue preference shares which are redeemable beyond 20 years, but not exceeding 30 years. Okay, the condition is that from the 21st year and going on forward, you have to redeem minimum 10% of your preference shares every year. Okay, then we have issue of bonus shares under section 63. Bonus shares are issued to the existing shareholders free of cost. Then sources are free reserve, security premium account, capital redemption reserve account, etc. It can be passed by recommendation of board, passing ordinary resolution, etc. Okay, then explain, the details are explained in section 63 of Companies Act 2013. Then further issue of capital, it may be either rights issue. Section 62 explains further issue to existing members. It can be in the form of rights issue, which is given by receiving payment from the shareholders. Bonus issue is issued free of cost. Rights is also issued to existing shareholders, but you are taking amount from your shareholders. Then employee stock option plan, which consists of three stages: granting of option, vesting of option, and exercising of option. The condition is that there should be minimum cap of 1 year between granting of option and vesting of option. Then preferential allotment under section 62 subsection 1 clause C, you are giving shares to selected number of your shareholders or selected number of persons. Then alteration of share capital is explained in section 61. You can alter share capital by passing ordinary resolution. You can increase the authorized capital, consolidate and subdivide the capital. Okay, you can convert share to stock to shares, then subdivide the shares. Okay, cancellation of shares, etc. Reduction of capital explained in section 66. Reduction means extinguishing or reducing the capital which is not paid up. okay, or reducing the capital which is not represented by assets, or repaying the capital which is not in requirement of the company, when the company is buying back its own securities from the shareholders, either from open market or existing shareholders on proportionate basis, or from employees to whom ESOP was granted. Okay, so buyback will be requiring either board's resolution or special resolution. Okay, then after buyback, there are certain requirements regarding the debt of the company. Okay, so for buying back the securities, authorization in the articles of association is required. If the amount of buyback is up to 10% of paid up equity plus free reserves, only board resolution is required. Then if it is exceeding 10% of your paid up and free reserves, you will be requiring special resolution. Then debentures can be issued. Secured debentures can be issued under section 71 by complying certain provisions. Special resolution is required. Then the period of redemption shall not exceed 10 years. Then infra related companies can have period of redemption beyond 10 years but not exceeding 30 years and all. Okay, then you have the concept of acceptance of deposits. Okay, so a company can accept deposit from members or public. So only eligible public company can accept deposit from public, eligible public company. So while you are accepting deposit from public, you are having certain conditions that has to be followed. You have to issue circular to all members, you have to file with ROC, etc. Then with respect to the quantum of deposit you can accept, the eligible public company can accept deposit from members as well as public. But normal company, the companies which are explained in 73 subsection 2, ineligible public company and all, they can only accept deposit from members. Okay, private company can accept deposit from members not exceeding 100% of paid up free reserves and security premium. Then eligible public company can accept deposit of maximum 10% of paid up free reserve security premium from members, 25% of paid up free reserve security premium from public. Okay, then other companies which are explained in 73 subsection 2, which is ineligible public company, can accept up to 35% of paid up free reserve security premium from members. They are not allowed to accept deposit from public. Then you are having the concept of registration of charges. So charge basically means interest or lien which is created on property or assets of company. So if charge is created, it has to be registered for an evidence. So normally the company will be filing with ROC for registration of charges. If company is not filing, if company is not registering the charges, the charge holder can register. Normally the charge get registered in 30 days. After 30 days, you have to pay additional fee. In the case of satisfaction of charges also, if the amount of the loan is being paid by the person, there is satisfaction of charge, that will also have to be intimated to ROC by filing the same within 30 days. Then details regarding registers there is register of members, debenture holders, security holders, foreign register, etc. Register of members will have to be preserved lifetime by the company. Other registers will have to be maintained for a period of 8 financial years. Then annual return, which is explained or which is filed in form number MGT 7, it should be signed by director and company secretary. If there is no company secretary, by company secretary in practice. If it is one person company or small company, annual return can be signed by the director or the company secretary of the company. It has to be filed within 60 days from the date of AGM or the last date on which AGM was to be conducted. Then now we'll move to the third part of your management and administration, which is normally related to types of general meeting, AGM, EGM, etc. So there are three kinds of general meeting: annual general meeting, EGM, extraordinary general meeting, and class meeting. Okay, so with respect to your annual general meeting, the time limit for holding is that normal AGM, that is subsequent AGM, you have to hold AGM within 6 months from the close of financial year. If it is your first AGM, it has to be held within 9 months from the close of financial year. You can conduct AGM on any day except national holiday, business hours 9 a.m. to 6 p.m. at registered office or at any other place within the town, city, village of your registered office. Then extraordinary general meeting can be called by either board of directors, 10% of or members holding 10% of paid up can request to board to conduct EGM. So board has to call the EGM within 21 days and conduct within 45 days. If it is not satisfied, the requisitionists themselves can call extraordinary general meeting, or in certain cases tribunal can also call extraordinary general meeting. Okay, so with respect to the prerequisites of a general meeting, there are three concepts. The meeting has to be properly convened, properly constituted, and properly conducted. So with respect to the properly convening of your meeting, there should be a proper notice. Section 101. Notice will have to be, or it should be in writing in electronic mode. Then notice has to be given at least 21 clear days before date of meeting. Clear day means the day of sending and day of meeting will not be counted. In the case of Section 8 company, 14 clear days notice should be given. Okay. Then explanatory statement will have to be given for special business. Section 102 of Companies Act. Then quorum is explained in section 103. With respect to private companies, the quorum is 2. Quorum means the number of members who are required to make a meeting valid. In the case of private company, 2 is the quorum. In the case of public company, if the number of members is up to 1000, quorum will be 5 members personally present. More than 1000 up to 5000, the quorum will be 15 members personally present, and if the number of members is in excess of 5000, 30 members personally present. So chairperson will be the person who is required to ensure that the meeting is conducted in fair and impartial manner. So any person, if a member is not attending in a general meeting, a person who is attending on behalf of a member is known as proxy. Proxy cannot speak or he cannot vote on show of hands, but he can demand poll and vote on poll. Then a person can become proxy of maximum 50 members. Okay, provided their aggregate capital is not in excess of 10%. Okay, then the representatives of president, governor, etc., representatives of body corporates, which are explained in section 112 and 113, they are having the right to vote in meeting. Even though they are like proxies, they will be having the right to vote in meeting, general meeting. Then voting in general meeting is explained in section 106, 17, 108, 109 and 110. So 107 is dealing with show of hands, 108 e-voting, 109 is voting by poll, 110 is related to your postal ballot. There should be a minutes, section 118, and inspection and maintenance of minutes in section 190. So these are the major provisions with respect to the meeting. Then now we'll move to the portion related to the directors, appointment and qualification of directors. So minimum directors and maximum directors required in a company. One person company, minimum 1 director, private company 2, and public company 3 directors, maximum 15 directors. This limit of 15 can be exceeded by passing special resolution. In the case of Section 8 company and government company, there is no maximum limit and special resolution is not required. There are two kinds of directors in public company, which are known as a rotational director and non-rotational director. So rotational director means directors whose tenure is not fixed. Okay, non-rotational means their tenure is fixed. So in public company, minimum 2/3 of the total number of directors to be rotational. Out of these rotational directors, 1/3 or nearest to 1/3 shall retire at every AGM. So once these directors are retiring, either they may be reappointed, another person may be appointed, or the company can decide to make that position, leave that position vacant. So we have the provision related to disqualification of directors in section 164. Subsection 1 is relating to personal disqualification. disqualification on the basis of default by company in section 164 subsection 2, additional disqualification for private company in 164 subsection 3. So personal disqualification basically means if there is any default on the part of the director itself, like if the person is unsound mind, undischarged insolvent, applied to be adjudicated as insolvent and application is pending, then convicted for any offense involving moral turpitude or otherwise and sentenced to imprisonment for 6 months or above, then when an order is passed by tribunal or uh, such other circumstances, you will be having the personal disqualification. If the disqualification is due to any default which is made by the company, it is known as disqualification on the basis of default by the company. If the company failed to file annual return or financial statement for 3 consecutive financial years, or if the company failed to pay interest on deposit, repay deposit, interest on debentures or redeem debentures, or pay declared dividend, and the failure continues for 1 year or above, it will be a ground for disqualification of directors. Such directors of the company will be disqualified for a period of 5 years for reappointment in the same company, or they cannot be appointed in any other company during that period of 5 years. Okay. Then you will be having the vacation of office of directors 167 subsection 1. So these situations are explaining the circumstances in which a director will have to vacate the office. Just like if a person is incurring disqualification under 164, then absenting himself from all the board meetings held during the period of 12 months, then contravention of 184, fail to disclose interest under section 184, etc. Then a director can resign by intimating the company in writing. The director's resignation will take place on the date of receipt of intimation by company or the date which is specified by the director, whichever is later. So for removal of directors, there is requirement of special notice. Special notice means a notice which is given by one members holding 1% of voting power or rupees 5 lakh, whichever is less. Okay, once the special notice is given, it will be discussed in general meeting and the director can be removed by passing ordinary resolution. But if the director is appointed by passing special resolution, you have to note that such directors can be removed only by passing special resolution. Okay, then director's identification number DIN is the number which is required to become a director. So it is an 8-digit number. It is required for becoming director. A person cannot apply, obtain, or possess more than one DIN. DIN cannot be cancelled, surrender, or deactivated. In certain circumstances, it can be deactivated or cancelled, like death of the person, when the person is becoming unsound, when the person is becoming insolvent. If the DIN is duplicated, if the two DINs are applied, one will be merged with validly retained number. If DIN is obtained in wrongful means or fraudulent manner, then if the person has not signed any forms after allotting the DIN, he can request to cancel the DIN. Okay. Then powers of board that has to be exercised at board meeting explained in 179 subsection 3, which may be normally referred as powers of board, like power to make calls, authorize buyback, issue shares, to borrow, invest, to grant loan, etc. These are the powers of board which can be exercised only at board meeting. Then you are having the provisions of board's report. 134 subsection 3, you are having the contents of board's report. Okay, the contents which are like the web address where annual return is placed, number of board meetings which are conducted by the company, then director's responsibility statement, details of fraud, declaration by independent director, company's policy on remuneration, etc. Such items are the contents of board's report. Then section 143 explains, 143 of Companies Act deals with audit and auditors chapter. So you are having rights of auditor. The auditor is having right to access books of accounts, get relevant explanation and information regarding books of accounts, to get the details of subsidiary company, to prepare consolidated financial statement. They are having, their duty is to report on every matters. They have to ensure that accounting standards, auditing standards are complied. They have to prepare audit report, etc. Then fraud reporting can be classified into two types. If the amount of fraud is less than 1 crore, it will be reported to board. If it is for 1 crore or above, it will be reported to Secretary of MCA, Ministry of Corporate Affairs. Okay, so if the auditor is having belief that fraud is being committed, it will have to be intimated to board or audit committee. Then they have to give reply or observation within 45 days. When it is received, or even if it is not received, the auditor will be reporting to central government in the case of fraud involving amount of 1 crore or above. Okay, in the fraud related to, or if the amount of fraud is less than 1 crore, it will be intimated to board. If remedial actions are taken, the name of the persons will not be mentioned in board's report. Otherwise, the name will be mentioned in board's report. Okay, so it is just a matter of mentioning in board's report if the amount of fraud is less than 1 crore. If the amount of fraud is 1 crore or above, 100% it will be reported to the central government. Central government in the sense Secretary of MCA. Okay, even if they are giving the reply or not, it will be reported to central government. Then you are having the provisions related to audit committee. Audit committee is applicable in listed company, then unlisted public company having paid up 10 crore or above, turnover 100 crore or above, outstanding, aggregate outstanding loan, debenture deposit in excess of 50 crore. Okay, so these are the major provisions, major topics. So as I mentioned at the start of the discussion, this is a revision session. So we have just included only the important main areas, main topics. Okay, so I know that with respect to some topics, I was a bit fast. I have omitted some topics because in such a revision, you can only include the major areas or major topics. Okay, so this is just to revise, refresh your mind before going to the examination. I think the discussion is clear to everyone. And if you are coming across any doubts, queries, or questions, you can ask me directly. There is no issue. Okay, all the best for your exam. Thank you.